I'm Siri Nelson, Executive Director at National Whistleblower Center, and I'm here with Michael Kohn, partner at Kohn and Colapinto and board member at National Whistleblower Center. We're here today to talk to you about non-disclosure agreements, which is a topic that Michael has a lot of experience with. Hello, Michael.
Hey, how are you today?
I'm doing very well. How are you?
Very good. We are able to talk today because we don't have non-disclosure agreements preventing us from doing so.
That is so true. Tell me more about that.
Well, when I started practicing law, like in ancient history, in 1985, non-disclosure agreements in whistleblowing were what it was all about. Corporations would grind down the whistleblower until they had no option but to just cave in and sign these NDAs. And the NDAs back then would say, you can't tell the government about your whistleblowing. And these all really started in the nuclear industry. You know, you can't tell the government about unsafe issues happening at a nuclear plant. You can, and if you tell the government about it, then you have to pay back all the settlement money and you have to pay our legal fees and you're going to be destroyed for the rest of your life. And they would sign on the dotted line, and in order to get some money to survive, because typically, you know, the companies had a scorched earth policy where they would go after whistleblowers and just crush them. And at the end of the day, they had no option but to sign these agreements. So eventually, one brave whistleblower came forward and was offered, for the time, an exceedingly large amount of money for a hush money agreement. This was 1988. It was $200,000 if the whistleblower agreed not to say what was happening. And that whistleblower has never had his name restored. He's been vilified for his entire life after that. His name was Saeed Hassan. And he refused to accept the money. And as a result of refusing to accept that money, another whistleblower came forward, because we were able to get large press coverage over this. And this was being paid at a nuclear power facility. There was turned out to be a $12 million total hush money settlement that was being paid with the understanding that you had to dismiss the nuclear license challenge on the safety of the plant and agree that none of your whistleblowers would ever go forward and testify or talk to the NRC again. And that was worth $12 million to the utility.
Can you tell us a little bit about the type of allegations that the whistleblowers were bringing that the companies were trying to silence?
Yeah, well, this one in particular, it was, he was a structural engineer, and he had identified that the pipe supports, which basically held the entire structural integrity of the nuclear facility, all of the wires and everything going into the central command center control room of the nuclear utility, were all compromised. And he exposed it. The Nuclear Regulatory Commission then did a study, and they issued a report indicating that if this problem had not been reported and fixed, and had there been a seismic event at the plant, it would have melted down. They didn't even use the word might or anything. They just said would. And that goes to show you the level of deceit that was going on in this facility, and why all of a sudden they were willing to pay $12 million in 1988 to get their license and have the whistleblowers walk away. Well, this one whistleblower wouldn't sign, and as a result of it, there was big news stories, and another whistleblower came forward. His name was Joseph Macdonald. And Macdonald came forward with a tape recording of the lawyers attempting to pressure him into signing this non-disclosure agreement. The tape reveals how the president of the contractor back then, which was Brown and Root, later became known as Kellogg Brown and Root, had flown in, the president had flown in on the private jet and meet him in a hotel room and offer him a suitcase of money not to go forward with his safety concerns. And he had been silenced by one of these non-disclosure agreements, and he had the strength to agree for us to make it public. And we published it to the Secretary of Labor, who had been dealing with his whistleblower case until it was dismissed as a result of signing this agreement. And we pushed that as hard as we could, and eventually got the Fifth Circuit Court of Appeals to issue a ruling saying that that agreement was unlawful, the entire agreement. The Secretary of Labor had earlier just like struck out the one sentence that was problematic and said all the rest of it is good. But no, the Fifth Circuit said the entire agreement goes out because it was an integral part of the agreement. And from that point forward, all of the nuclear environmental whistleblower cases, which by that time, other than federal whistleblower cases, were the only real federal whistleblower protection laws on the books. So with that one case, we were able to do away with NDAs for all essential whistleblowing that covered all whistleblowing in the United States that was covered by laws except for the federal side. Later on, as you know, Whistleblower Center was very active in getting new legislation passed. You had the Dodd-Frank Act and a lot of other financial type, you had the IRS whistleblower laws, and all these laws, you're now dealing with typically higher level managers who have the type of information needed to turn in a company. And the standard was for every high-level manager to sign a non-disclosure agreement sometimes before they started working and certainly when they left. And that was just a standard practice in the industry. And as a result of the Macdonald case, and in a deposition I was doing, and it happens to be Kellogg, Brown and Root, you know, I guess they begin it and end it. Kellogg, Brown and Root had a practice where they would do these internal investigations and require anyone who was associated with the investigation to sign a non-disclosure agreement saying they wouldn't tell anyone what they discussed or knew about the investigation. And we presented that to the Securities and Exchange Commission and got a rule, basically got them to prosecute Brown and Root. And there was an agreement reached that that NDA was unlawful. It was SEC published the determination, which then set the standard for all of the regulated industries that such NDAs are now unlawful around the world, as long as you're regulated by the SEC.
So what types of clauses are in NDAs that people should look out for to see whether or not the NDA they're being asked to sign is lawful?
Well, I think first, it matters whether you're going to be covered by the good laws that prevent them from silencing you. And just because there's laws on the books that prevent you from silencing you doesn't mean they are. So if you're working for some company, any company that is traded on the stock exchange, then you're definitely going to be covered. They cannot put in statements in your agreement that say you can't go to the government with your concerns. They can't put in statements saying that you can't recover rewards, because one of the most important aspects of the SEC and IRS laws are that the whistleblowers get to recover a reward for the information they turned in, which is also a major shift in how whistleblowers are treated these days. Instead of being destroyed like Mr. Hassan was and never having his life back, now you have whistleblowers who can go anonymously and report these things. And so putting in these agreements terms saying you're not allowed to, would stop these higher level employees from going forward, unless they know that they have the right to go forward, whether or not they sign it. So you can sign an NDA that prohibits you from doing it, but then you're still allowed to do it. And in fact, you can turn in the company and report them for trying to silence you with this NDA. That's basically you read between the lines. The purposes of these NDAs is to put enough language and put enough doubt in the whistleblower's mind to make them believe it's not in their interest or they're prohibited from going to the SEC. And the more language they put in like that, the more troublesome the NDA becomes. And at some point it becomes illegal. But at no point can they ever prevent the whistleblower from going to the SEC. That's what's most important to understand. Just go.
So you're saying that NDA should not dissuade people from coming forward with information about wrongdoing that they have, particularly if they're reporting to the SEC.
Yes. And then secondly, go to a reputable law firm. You are allowed to share your NDA with any lawyer to get advice as to what it's really doing and whether it's legal or unlawful. So, my law firm, we look at these things all the time and help whistleblowers out. And it's a very important factor. If you're in Europe, the odds are you got an NDA. They haven't really caught up with the United States. US companies are getting a little bit better at not putting repressive language in their NDAs anymore, or in their settlement agreements, or in their retirement agreements, whatever. It's basically whenever you're leaving or coming from a large company, there's typically some sort of NDA language in there. And in the European countries, they're still prohibiting people from going to regulators because they're not really in tune with what's happening here.
Mm-hmm. And so if someone lives in Europe and they decide they want to report to a US regulator like the SEC, and they have a NDA in their agreement, whether it be their employment agreement or a severance agreement, are they going to be protected by the rules that prohibit these NDAs?
Yes and no. First, in the country you're in, it may be unlawful, okay? But doing it in the United States would make it lawful. But you live in a foreign country, so you have to protect yourself. So then you're pretty much limited to, like, the SEC has a rule and the IRS has a rule where you can file anonymously. So you file anonymously. The only name the SEC gets is the whistleblower's attorney's name. And then the attorney can protect your identity so you don't run afoul of your local laws that may prevent you from making such disclosures. Of course, then you have to watch out for how you communicate with your lawyers. It has to be through secure means. You have to make sure that the people you're communicating with, your lawyers, understand the security nature of your communications, and then you can get protected and bring forward the information. And of course, if the SEC uses it and obtains a recovery, then the good news is the whistleblower also gets a reward in addition to helping stopping the fraud.
What do you think is the most important issue related to NDAs today?
I think it's really the framework of the company, and it's really the corporate mindset. Some companies, they are just so entrenched in covering things up that it will always be that way. And basically, you can also look at the corporations. Does their auditing department report to the general counsel's office, or does it report to a company officer who's not an attorney? Because if it's reporting to a company officer who's an attorney and the corporate counsel, then everything's covered by the attorney-client privilege, and they can cover everything up, and they do, and that's how it works. And so so look on your corporate chart, see who your auditing department is reporting to. And if they're reporting internally to legal counsel, do not go there. Go outside, go straight to the SEC. Because if you do the internal route, you will be identified. And if it's ever identified, if it ever makes it to the SEC, they will ultimately know you're the source, and you will be retaliated against.
So the main takeaways are: find out how you can report anonymously and if you can report anonymously. Do not let any NDA stop you from reporting wrongdoing. Find an attorney that knows the law and can protect you. And make sure that if you decide to talk to anyone in your company, you understand the structure and what may happen after your report. Is there anything else we should add?
Just know that you're doing the right thing. If you do it right, if you're dealing with the SEC and the new modern laws, you have so much more protection than you could imagine. They are the most protective laws in the nation as far as whistleblowing goes. So feel secure and just make sure that you're not using a company computer, that before you do anything, you consult with a lawyer who's familiar with the whistleblower laws and the rules and regulations. And you will then be able to walk through a relatively easy path to get your information to the right people without any harsh reality falling on your shoulders.
Well said. Thank you so much, Michael. I hope this information was useful for you if you're thinking about blowing the whistle. Don't hesitate to visit our website, www.whistleblowers.org. That's whistleblowers with an S. You can also check out KKC's website, www.kkc.com, to find out how to get representation from a skilled attorney, or check out Whistleblower Network News to stay updated about the latest breaking stories, including news about NDAs. Thank you.
Remember, thank Saeed Hassan and Joseph Mactel for having the courage and fortitude to expose this practice of illegal NDAs and putting an end to it.